Hey everyone, welcome to today's video. I've got a sovereign citizen case for you that I totally forgot about. I was just waiting for the court case to wrap up, and wow, the ending was even better than I expected. Not because anything crazy happened, but because the judge's reactions to the sovereign citizen's responses during the discovery phase were priceless. But before we dive in, let me tell you about today's sponsor, HIMS. Normally, I try to blend these ads in, but this one is too important to skip. HIMS is an online telehealth service that connects you with doctors for things like hair loss and erectile dysfunction. They use certified doctors and FDA-approved treatments, so you don't have to worry about bizarre remedies like sticking a rose somewhere inappropriate. Do I use it? No. Should I? Probably. In fact, I'm taking a break from my vacation to fill out a consultation myself. If you're like me and your hair is thinning or you're not performing in the bedroom like you used to, check out HIMS. The consultation is free, and it could make a big difference. Use a link in the description, the pinned comment, or scan the QR code on the screen.
Calling 2-1-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. No appearances.
Good morning, Your Honor. May it please the court, Suzanne Strickarts, P44018, on behalf of the plaintiff.
And your name, sir?
Kevin Hurst.
Okay, where are we on this file, people?
Your Honor, we had a pretrial. You opened up a written discovery. We did send discovery out. We did receive it back, apparently unopened, indicating there was a written on the envelope itself. It had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308 signed, and then it was a return to sender, Judge.
All right,
So
Mr.
we attempted to do discovery anyway. So.
Mr. Hurst, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that comes to me.
And what does freeze even mean? Are you having a seizure or something? Because you have to be out of your mind to think that writing in washable highlighter on the outside of your discovery packet, saying you don't accept it, is going to get you out of the legal mess you created for yourself.
One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
All right, here it is. I open written discovery in this matter. You have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
Your Honor.
You don't want to accept it.
I'm not even sure. I do not have any understanding of this is my debt or not.
And what do you think was in that packet you refused? Not accepting your discovery packet was probably the dumbest move you could have made. Now you're heading into trial without knowing the exact charges or the evidence against you. They just coming with these
allegations. I'm trying to see and verify if it is. When they called me the first time, they should have sent out verified documents stating that the original creditor and who it was and that I truly owe this debt.
Well, Your Honor, just indicate that we did attach to those.
They already
excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. I wasn't finished. She cut me off.
Mr. Hurst, I'm not going to have this.
Your Honor, she cut me off.
I'm not going to have this. Talking. This is not a clown show.
Oh my goodness.
One at a time.
I can't finish my statement.
You will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr. Hurst.
I don't understand anything.
Okay,
I
fine.
don't even understand why I'm here.
I'm going to mute
I don't
you.
even understand what's going on.
Oh, I'm sure of that. Honestly, I bet you can't even tie your shoes without accidentally trying to
Hurst,
eat one of
and
your
I will let Ms.
socks.
Strickhart say what it is she wishes to say. Then I will unmute Mr. Hurst and allow Mr. Hurst to speak. Ms. Strickhart, you were responding, Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in, all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Okay, so the understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt. Yeah, I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refuse the packet, because I don't know if they're trying to contract with me or not.
Trust me, sovereign citizens are financial black holes. No sane person would
I didn't know
want to do
what it
business
was,
with
so
you.
I send it back.
All right, let me explain it to you again. Whatever political views you have,
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery, and she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules cut against you, then so be it.
Sounds like a fair deal to me. If you want to ruin your own life, go for it. No one's stopping you from hoarding all the paint chips at the breakfast buffet. Especially not Judge Robinson, who's definitely going to get a good laugh at your expense by the end of this video.
They are claiming that this debt belonged to me, but they have to produce all the proof and verify that this debt belongs to me.
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she had to produce the proof that this debt belongs to me, right?
She has the burden of proof.
Okay. Thank you.
All right.
Judge,
I'm sorry, Ms. Rickards?
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
Let's give him one more opportunity.
Oh, you want me to resend the packet, Judge?
I want you to resend the package. And sir, let me urge you as strongly as I can. So receive and open the package. Because if you do not, the request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said to you?
Yeah, I understand. Do you I got a question. Should they have sent me something before they send me this package since the last court date?
Sir,
to verify that?
Sir, they're not required. If you think you need some information, you have the right to seek discovery too. But you can't tell them how to litigate their case.
Okay, so she's going to send me a packet, and I'm going to send her back a packet as well, right?
No, you're going to do what you choose to do. She's going to send you again those requests for admissions.
Well, you said the
Don't
discovery
interrupt me again.
for me
We had
and
this
her.
conversation before, didn't we?
Sorry.
We
Go
had
ahead.
this conversation before.
Go ahead.
As a courtesy to you, she's going to send you the request for admissions one more time. You will either accept the package or you will not. You will answer and serve the request for admissions in accord with the Michigan court rules, or you